right now. Welcome everyone to today's NIWAP webinar on obtaining U visa certification from judges in protection order, family, criminal, and other state proceedings. We're pleased to have you being able to join this webinar that is presented by the U.S. Department of Justice Office on Violence Against Women in partnership with Legal Momentum, the National Immigrant Women's Advocacy Project, NIWAP, and the California Coalition Against Sexual Assault.
David, if I can add that today this webinar is also, in addition to being sponsored by OVW, is being sponsored by the State Justice Institute through funding to NIWAP on a project for training judges on U visa certification and a range of other issues that affect state court judges.
Thank you, Leslie. And as we have the disclaimers here noting that these projects are supported by the grant numbers and that the opinions, findings, and conclusions and recommendations expressed in this program are those of the authors and do not necessarily represent the views of the Department of Justice Office on Violence Against Women and do not necessarily represent the official positions or policy of the State Justice Institute. Thank you very much. So I want to just talk briefly about how to use this technology. The first thing I want to be able to let you know is that there are ways that you can be able to participate. We can have people raise their hand. And what you do is you look on the far left column, you see my picture, and you'll see a hand above that says my status underneath it. Now everyone please raise their hand. That would be great. Thank you. I see that many of you, we've got wonderful. People are raising their hands. It's just one of the ways that we'll be able to have people interact, and we want to be able to have you participate in our web conference. Thank you very much. I see I've got over 70 of you have raised your hand. I'm going to lower all the hands now. We also do have the text chat. The box for text chat appears on the right-hand side of your screen. Most of you have figured out because you've written what cities you've come from. We'll have to write out the audio. If you're not getting, I will write that down now, or if Chad is able to write for audio, call 1-888. Great. So to do the text chat, you've figured out how to be able to do that by sending the message. We just write a message here and click, and this is just a great way to be able to get messages across to all of us. And so I want to encourage you to be able to write messages there. We will be answering questions from that place, and Chad's already given the phone number, and I've also given the phone number to call in. Mine was missing an 8, I see. So you go over to that. We will have a copy of the text chat that will be available, so we'll be able to review questions that you ask that we aren't able to answer in today's call. You can see we expect over 300 people joining today's web conference. There are slides, PowerPoint slides, and we will I will need to write those in. I will get that shortly and write to where to get the slides to be able to get there. And as Chad said, you can use the text chat to be able to write any messages that this is there. And Rocio, if you're able to put the link to where to get the slides from today, I would appreciate that. We do have some polling questions that we'll be asking a little bit later about who's in the audience, and so I'll be doing that shortly. And that you are on the phone, we're asking you to keep your questions to the text chat, and we will, that's how we'll be doing questions during today's session. If you need to send information, you can send a private text chat to us. And you can also go ahead and call Island Technical Support if you're having trouble getting online at 800-799-4510. And I do have to apologize, we do not have the captioning functioning today. I do want to introduce our speakers that we have today, and I am pleased to be able to have Judge Ramona Gonzalez and from La Crosse, Wisconsin. How are you doing, Judge Gonzalez?
I'm fine, David. Happy to be here.
Great. I'm really pleased to be able to have you joining us today. And of course, we are joined by Leslie Orloff, who's the director of NIWAP at American University, Washington College of Law. Hey, Leslie.
Hello. Nice to be here. Thank you all for joining us.
Well, it's really exciting to see so many people joining us, Leslie and Judge Ramona. This is the 6th webinar in a series of 7 webinars that we've been holding. Recordings of these webinars are available on the NIWAP website, so along with resources. So I want to encourage you to be able to get that information, and Rocio has posted a link to be able to get that information for this webinar and other webinars. I do want to get a sense of who's in the audience so we can see who's here. So in the left-hand corner, you're going to see a little box, and let's go ahead and just have people check the box and let us know what best describes you. Are you A lawyer or an attorney? B, are you a domestic violence or sexual assault victim advocate? C, are you a judge or court staff person? And go ahead and click on the left-hand corner box so we can get a sense of who is in here in our audience. So Leslie, I'm looking, and we've got a lot of people voting. Not everyone has voted, but a lot of them have. So let's share the results, Leslie, so we can see. Almost half of our audience are domestic violence and sexual violence advocates, that we have about 35% of our audiences are lawyers, that we have approximately 8% are judges or court staff, and we have about 10% are other. So if you're other, go ahead and write down what the other is. And we will, for those who don't have sound, we will have to let people know how to get sound. So it's great to see we have a BIA rep, paralegal, and being able to see some people, a wide variety of different places that people are joining us from. So it's great to be able to see that range of participants here that we have. Thank you. And great, so I'm going to move on to the next question that we have. And this is our next piece, which is our learning objectives. And the learning objectives are for this session are to promote advocates and attorneys seeking U visa certifications from judges, to understand when judges can sign U visas and approach judges for certification in family, civil, and criminal court cases, identify the reasons why courts may not be signing U visa certifications, to anticipate and overcome challenges, and develop a plan for approaching judges for certification. So great. So this is what we are intending to do today. So my next question I want to get a sense of is from your audience, and this is the left-hand corner, yes or no. Have you worked on a case in which a judge was asked to sign a U visa certification? So let's go ahead and see in our audience, and I know that still most of you have not voted, so go ahead and vote and just click on the left-hand side. And actually I'm showing live results as it's coming in. And so you can see that Leslie, and Judge Gonzalez, about 3/4 have not worked on a case where a judge was asked to sign it, and about 1/4 of our audience has been asked.
For me, that's very exciting. This is Leslie. To see that 1/4 of you have, that's actually a higher percent than we expected, and it's really we're very happy to see that. And we'll be talking so that ideally the next time we do this on the next webinar, we'll have them flipped. It'll be 75-25. But great.
Great. Well, thank you very much. So let's move on. And Leslie, I'm going to hand the podium over to you.
Thank you. Want to welcome all of you here today. The focus of this presentation is going to be talking about why courts were authorized by Congress to be one of the U visa certifiers, and how important, and that there are various paths to visa certification. We hear a lot about people going to law enforcement, but the goal here is to expand where people can get certification so that the greater numbers of victims are able to access protection. When Congress enacted VAWA self-petitioning, the T visa in '94 and the T and U visa in 2000, the goal was really to help bring, open up the ability of the criminal justice system and the civil justice system to help immigrant victims of domestic violence, sexual assault, human trafficking, and other crimes, because there was an understanding in Congress that there were multiple purposes served by that there would be perpetrators of crimes who could be serial crimes when we talk about things like rape or domestic violence that would be essentially unsolvable in our communities and in our country if there were a subset of victims who couldn't come forward and seek protection, or whom perpetrators could coerce or control or threaten with deportation if they came forward. And so VAWA was really designed to enhance justice system protection. And in a lot of ways, U-visas and U-visa certification are the entree or the beginning step in that process for many victims. And that one of the things that is important to understand is that when Congress created these provisions, they did so understanding that the vast majority of victims who would benefit from the provisions would be undocumented. But despite that fact, the goal that they also recognized that being unlawfully present in this country is not a crime in and of itself, and that they didn't want someone's undocumented status in the country to preclude their ability to call the police for help, to assist in a lineup, to seek a protection order, to testify in criminal court, to get custody of their children in family court. And so they created a whole range of remedies that are available to help immigrant survivors. And how many of you on the call, if you could raise your hands, are familiar with the entire list of remedies that you see on the screen? How many of you are familiar with the ones? And I'm talking about the VAWA self-petition, cancellation, battered spouse waivers, the T visa, the U visa, special immigrant juvenile status, DACA, which is deferred action for childhood survivors, and DHS's prosecutorial discretion. So it's looking like people are still coming, raising their hands. I mean, that's a long list, and some of you may be more familiar with some of these than others. But it looks like maybe a third of you almost are familiar with most of them, or all of them, which is great. Today, we're going to be focusing on the U visa, but it's important to understand that when you're working with an immigrant victim, kind of reviewing this list and knowing how to screen for various remedies is important, because sometimes in traveling around the country and doing trainings, and particularly when we're talking with judges or law enforcement and prosecutors, people may be looking for U visa certification in a case where the remedy is really a VAWA, the Violence Against Women Act self-petition, or maybe special immigrant juvenile status. So these are not mutually exclusive options. And I'm just going to very quickly say that, generally speaking, we're going to summarize very quickly right now the ones that are not the U visa, that are not the focus of this training, just so people are all kind of have the same baseline of awareness what those remedies are. The VAWA self-petition, designed to help in family violence cases, and it generally helps people whose perpetrators are their U.S. citizen or lawful permanent resident, spouse or parent. Also includes, for those family lawyers and judges in the audience, stepchildren and step-parent relationships, whether or not there's been any official custody or adoption. And it also covers elder abuse victims or older vulnerable adults where the perpetrator is that person's over 21-year-old son or daughter. There's something called VAWA cancellation removal and VAWA suspension of deportation. That is the relief in immigration court should a perpetrator be the two biggest ways that we know that immigrant crime victims end up before immigration judges, either their perpetrator turns them in to DHS, or many, many victims are getting stopped during traffic stops and turned in by local police. And so there is a remedy for victims of family violence in the immigration court context. There's something called a battered spouse waiver, which are cases in which the perpetrator of domestic violence, who's a U.S. citizen or lawful permanent resident, actually began a family-based visa case for the victim, and the victim can, instead of having to remain in the abusive relationship for 2 years, file their own papers to get out. There's T visas for trafficking victims. These are victims of severe forms of either human labor trafficking or sex trafficking. As you will hear later on today, the U visa, trafficking is also a U visa crime. For children, there are two major forms of relief. One is a special immigrant juvenile status, and we have lots of materials online and other trainings that we've done for judges and materials available for judges and advocates on special immigrant juvenile status. This is available to children generally under the age of 18 who've been abused, abandoned, or neglected by one or both of their parents. And again, we have lots of materials online that I'll have Rocio or Gina post where you can get those materials online in our web library. And then there's deferred action for childhood arrivals, which basically many of you may have heard of. It's a program that doesn't offer immigration status but offers protection from deportation and work authorization to children who were brought over to the United States at a young age and were essentially raised here. Many DACA immigrant kids also may be crime victims and may qualify for VAWA or U visa relief. And so it's important to be aware of that. And then finally, it's important to understand that over the last several years, there have been a series of DHS policies, which again we have in our web library, that make it a low priority for immigration. Immigration enforcement resources are not supposed to be being spent on removal of immigrant victims, immigrant witnesses, parents of young children, particularly U.S. citizen children, or primary caretakers of children, the elderly, the disabled. And that could be useful if you're working with an immigrant crime victim who, let's say, may not, let's take a sexual assault victim, who may not feel like they're willing to come forward and make a police report, so they may not be U visa eligible, or there might be a trafficking victim who, again, is not necessarily ready or willing yet to cooperate with law enforcement, and in those cases, these prosecutorial discretion remedies can be very helpful. When we talk about, now I'm going to be switching over to U visa crimes, and when we talk about U visa criminal activities, NIWAP conducted research in 2011, and we got reports on about 4,000 cases from agencies, domestic violence and sexual assault agencies, legal services agencies across the country. And this slide gives you the breakdown of how U visas are being used. A significant group of U visa cases are domestic violence cases. The next largest group are rape, sexual assault, incest, and human trafficking. Some more recent research that we've just completed and are going to be sending to everyone next week, we're ready to publish, found that actually the U visas are being used extensively by trafficking victims in addition to domestic violence and sexual assault victims. And then you also see the range and the percentages of the other kind of serious crimes that the U visa covers and what some of those numbers look like. I'm going to turn right now to talk briefly about the Department of Homeland Security and kind of how it works. And this is important for those of you that are both working at courts but also talking with courts about U visa certification. And Judge Gonzalez will talk about this later as well, but what we're finding as we're traveling around the country and training judges is it's helpful for everyone, including judges, to kind of understand how the Department of Homeland Security is structured and how the interaction, how there's opportunities for the courts and the Department of Homeland Security essentially to work together, and that by signing certifications, it enhances the ability of courts, because victims have more access to relief and protection, to do things for families and to help with the options in a case before a state court judge. So the Department of Homeland Security, at the highest level, you have the secretary, and you have certain areas of, for example, the Blue Campaign, which is the campaign on human trafficking and protection of crime victims. You have the Office of Civil Rights and Civil Liberties that is responsible for enforcing VAWA confidentiality protections. Those are agency-wide. The two enforcement branches or arms of the Department of Homeland Security are Immigration and Customs Enforcement, commonly referred to as ICE, and Customs and Border Patrol. And then there is the U.S. Citizenship and Immigration Services, which is the part of the Department of Homeland Security that is responsible for granting lawful visas, legal status, lawful permanent residency, and naturalization cases. The Department of Justice is where the immigration judges and the Board of Immigration Appeals are located. And that what's really important, and you will see in some of the videos we're going to be showing you in a little bit later in the webinar, is that DHS, just like any court or law enforcement agency in this country, every court or law enforcement agency in this country has multiple laws that it's responsible for implementing, enforcing, interpreting, etc. Well, since 1994, when the Violence Against Women Act passed, the same is true of the Department of Homeland Security. So people think, generally when you think of the Department of Homeland Security, you think their job is to remove people from the United States. That is part of their job, but the other part of their job is to provide, to adjudicate cases of lawful permanent residency, of visas, of naturalization, and equally to protect crime victims. And the Department of Homeland Security, as you can see from many of their materials that are available on our website and on the Blue Campaign website, they are as committed to crime victim protection and facilitating access to visas for immigrant victims and immigrant children as they are to any of their other functions. And those functions are all equal under the law. David, I'm going to pass this back to you for the video.
Okay, so we're going to just show a very short video. Now for the sound, for some of you, the sound will come through the computer. For some people, the sound will come through the phone. You might want to adjust that. And for some of you, you might want to go directly to the website. This is a very short PSA, so I'm going to play this right now.
Every day we go about our lives driven by routine and blindfolded to the realities of the world around us. Our vision is clouded by the very normalcy we take for granted. Countless victims of human trafficking walk among us, seemingly invisible. Until now. The Blue Campaign provides a unified voice for those who oppose the heinous crime of human trafficking. Whether it's forced labor, domestic servitude, or the sex trade, it's time we open our eyes. Sorry. Learn what you can do to help by visiting dhs.gov/bluecampaign.
And I do know that some people had trouble hearing the video, but you will be able, the link is provided above that you see that Gianna had posted that, and here's the link also, so you can be able to watch this later on. Back to you, Leslie.
So when we talk about state courts, what it's important is, what I like about that video is it really shows you how Department of Homeland Security views the importance of identifying victims. And so what happened, David?
Oh, okay.
Okay, so essentially this infographic, so to speak, what's important about this is that what happens in state courts, so if a state court judge in a family court or criminal court case certifies a U visa, you can see in the bottom left corner that that U visa certification enables the victim to apply to the Department of Homeland Security for relief. It might be relief in a U visa case, or if the court informs by distributing brochures that we have available on our website from the Department of Homeland Security, about relief available. If courts make those brochures available, so somebody comes to court for a protection order and they learn that they will be able to get forms of relief because they got the information from the court, people apply for relief for the VAWA self-petition or a U visa, and that process that you see aligned to HHS, that process makes them available. It begins them on a path either through the T visa or the U visa or VAWA, and what benefits they get differ. But it gives them an opportunity to get some benefits, things like better protection from deportation, access to work authorization, that then again go back and make it easier for the state courts to order remedies and to and Judge Gonzalez will expand on that later. But that these are all interconnected, and that if you get relief, let's say in the U visa, if you have a case at DOJ before an immigration judge, that case will get closed. And so all of these systems in the state courts play a role in helping victims get status, and then also in expanding the remedies that state courts can offer because victims and their children have more access to benefits. So who can sign a U visa? When we wrote the legislation in 2000, there were lots of discussions, and we understood in working with Congress, or Congress understood, that depending on what jurisdiction you are in the country, some places will have police departments that will certify, some may not. Some will have prosecutors that will certify, some may not. The first person, an immigrant victim, their point of entry in the system may vary. It might be somebody from Adult or Child Protective Services. It might be that they end up seeking a protection order first, and they first learn about help available from the courts. It might be that it's a victim of sexual assault in the workplace where it's the EEOC that is their first point of entry. So that Congress created a broad list of government agencies whose essentially day jobs involve determining whether or not they think a crime occurred or some kind of criminal activity occurred, whether they think this person is a victim. And that list of that range of people are eligible to certify, and one of those certifiers are judges, and that's what we're going to focus on today.
Great. So Leslie, let's ask a question of the audience. Why did Congress include judges in the U visa statute as certifiers? So I'd love to hear from our audience. Why do you think that Congress included judges in the U visa statute as certifiers? So let's go ahead and see what people are going to be responding to this. So I'd love to hear what people have to say, because law enforcement's not approachable to protect the pro se applicants. They detect criminal activity, and the judge, because they work with the victim and have firsthand knowledge. If they cooperate with the prosecution, law enforcement often doesn't want to help. I'm seeing a little bit of a theme of concerns about law enforcement. Not all victims make a report to law enforcement because they can make a determination of criminal guilt. They know the law. Immigration is a federal matter. Accessibility. Judges are officials. This is going very fast. Magistrates in the upper level of criminal justice. They have political power. It keeps it uniform. Sometimes the custody case is the first report of domestic violence. They're part of the prosecutorial process, so they know the case can dictate sentence. In my county, only the DA is signing. Judges have the power to determine a course of action. In the case of the U visa, so Leslie, I'm noticing a lot of different pieces. Less questionable. They can review quests. Certain law enforcement officers are not informed enough to sign. Well, let me turn this question actually to you, Judge Gonzalez. Why do you see Congress included judges in the U visa statute as certifiers?
Well, I think the audience has quite a good handle on why it happened. And if you show the next slide, I love my graphic. ta-da, because judges like to be the solution and not the problem. If we can understand that judges make decisions as decision makers and not by committee, that they are able to be on the ground floor, actually seeing and viewing the people who are going to benefit from these visas. And sometimes, given the cultural issues involved with immigrant populations, they may not trust law enforcement. And so the first point of entry for them into the judicial system in which they might find some trust is the judiciary. And so to me, it gives victims an opportunity to sort of have a direct line, an individual who is going to probably be the first one who they have been able to communicate with in their own language, since we have to provide interpreter services. And instead of having to go through many, many hoops and other policies and procedures implemented in other agencies, a judge can really just get to the nub of what the problem is and render a decision. Want to go to the next slide?
You can advance them. You have the...
I have it now?
Yes, you do. I'll help you.
Help me because I don't see it. Thank you. But what this presents for us, though, is that there are some problems because judges don't necessarily have any knowledge whatsoever about U visas, especially state court judges who see immigration issues as a federal purview that they don't really have an entry into. Basically, a lot of us just feel like the only contact we have with immigration issues is when ICE shows up in our jails to pick up people. That's basically it. So there is an educational component that has to happen, but part of that is what Leslie just mentioned, is if we can have judges understand that the U visas are available, we can make that information available in our courthouses, and we can spread the word to more victims who are in need of these services. There's also, each individual judge has discretion. In the state of Wisconsin, I'm an elected constitutional officer, so I exercise my own discretion. I don't have to worry about policies or procedures or practices from agencies denying certifications for whatever reason. And there was a survey that was done asking just why certifications are not being signed. And I think, Leslie, you provided this information to me this morning, and it was really interesting to see the kinds of reasons that people were giving for not signing, things that were absolutely contrary to what DHS published positions and policies are. Because there's a sense that, oh, if the criminal wasn't prosecuted, we don't have to sign the visa. If the victim doesn't have any injuries, we don't have to sign. When really, it's all about trying to get help to individuals who need it so that they can come forward and justice can be done. And David, I'm still not seeing where I forward my slide.
Well,
thank you.
Next one is mine, actually.
Okay.
So what I just want to briefly explain we did research in April 2013, in which 722 agencies from 50 states reporting on 22,000 cases of immigrant survivors of domestic violence and sexual assault and human trafficking. And we were trying to learn what the interactions with police looked like and where the problems were. And essentially what we found was significant language access problems in terms of, with a relatively low level of police around the country using qualified interpreters, 29.4%, and that oftentimes they were using the perpetrator or other unqualified interpreters to translate. And so we raised this. First of all, we can make that survey available. The other thing, I'll be talking about it later on in this training, because one of the other really powerful findings, first of all, 9% of the people participating in that survey were government agencies themselves, and those government agencies overwhelmingly reported that where they had ongoing relationships, working relationships with nonprofit organizations, NGOs, legal services. Language access went up and U-Visa certification went up. Similarly, the National Center for State Courts did research among court programs and how much access limited English proficient victims had to protection orders, and they found the identical thing, that where courts had established relationships with nonprofits working with immigrants and with nonprofits working with immigrant crime victims in particular, access to the courts went up and it benefited both the victims and the court system. Back to you, Ramona. Judge Gonzalez.
So, you know, the Department of Justice issued a letter back in August of 2010 that basically put everyone on notice again that access to justice is a civil rights issue, and that if you aren't providing assistance to limited English proficient persons, then you may very well be violating their civil rights. And so the court system has really been on the front line of providing assistance to limited English proficient persons to access the court system. And this is much more than just what happens inside the courtroom. For this directive requires that we make available to individuals, that LEP individuals, services that go outside the courtroom. It's not just what happens inside my courtroom that's important. It's how the forms are that gets them in here. It's whether or not they can communicate with my court staff before they get here. It's whether or not they can communicate with prosecutors trying to get the information out. So it's really important for the courts to understand that in this particular U-Visa certification process, that many times the individuals who come into court and are important for us to establish the facts of our case may not be ready to disclose those facts because they simply just don't understand how the system is working. It's really a call to action to state courts. Not all state courts have embraced our requirements, and we're all, because of fiscal responsibilities and resource restrictions, try and figure out ways to do it on the cheap, but we still have to do it. And I think that that is one of the reasons why judges have the power to sign these certifications.
Great. Thank you so much, Judge Gonzalez. I do want to note that people are asking questions in the chat, and that I want to really thank Rocio Molina and Gianna Lee, who are providing answers to those questions. So please go ahead and post questions in the chat, and we will be able to answer them as we move on. We will not be doing questions over the phone, though, so just want to let you know. So let's ask another question of the audience. How do courts, so we want to ask all of you in the audience, how do courts benefit from U-Visa certification? What is the way that courts can benefit from U-Visa certification? And so let's go ahead and I see there's a discussion going on about the challenge to get family court judges to be able to sign and also requests for training. But let's go over and talk about what is the benefit for courts. I think this is part of that answer of how to do this. It encourages victims to come forward, increase cooperation. Victims are available to testify in court. People show up in hearings, cooperation, consistency. And so more non-citizen crime victims will report and help with prosecution. So the theme is that more victims will come forward and more victims will be able to then cooperate with the system that leads to prosecution. It serves justice. It increases prosecution opportunities. So I think that's a real theme that I am seeing. Judge Gonzalez, what's your thoughts? How do you see courts benefiting from U-Visa certification?
Well, I think I would take it a step further, because judges and courts are to be finders of fact. And it's very difficult to find facts, accurate facts, and dispense justice when people are reluctant to give you that information. So for me, if I can encourage an individual, an LEP person or a victim of a crime, to understand that their information can and should be truthful, and they do not have to be fearful of the intimidation by the other party, that they can then provide me the accurate information that I need to make the correct legal orders and decisions. And so it's not just about criminal cases. It's also about me making determinations as to custody and visitation. If you have someone who's being coerced about, I'm going to see that you get deported if you don't give me the children, that's really a very difficult decision to make. And sometimes people want, not understanding the language, not understanding the court system, are intimidated quite well by those who would want to gain an upper hand in court. So for me, it's about providing accurate information to the court so that I can then make just and fair decisions. And so we can protect children, we can protect the integrity of what justice means in this country. It's also about providing accurate information because there is so much disinformation about immigration law and policies in the United States out there. And as a court, I have the opportunity to provide more accurate information that encourages victims to step forward. It's hard to issue orders in protection orders in domestic violence cases where you don't have the accurate information. And it's very difficult to protect children in child in need of protection or services or welfare cases if you don't have the information. So the fact that the court can encourage you visa applications and certifications to be able to give those individuals some status so that then I then have more options available to structure my support orders.
Leslie, why don't I hand it to you?
Okay. Actually, I think so. So as Judge Gonzalez just summarized, this really does help courts make their decisions, and it also helps build trust, as we talked about earlier, in the justice system. And what I don't know if I have control, David. It's not going down.
You do have control.
There we go.
There we go.
Picking up on what Judge Gonzalez said is that if you think about, let's take a child custody case or a child abuse case. Lots of times the courts are going to want to order parents maybe to get certain services. And when part of the role that getting immigration status for an immigrant victim, getting that process started earlier can do is it can open up the range of possibilities that are available to support that family, to help a battered immigrant mother keep her child, to help the battered immigrant mother if you, let's say, file a VAWA self-petition, or if you're in a state that allows people who file for U visas or VAWAs to get certain benefits. It opens up the options that Judge Gonzalez was just talking about. So what I wanted to do is just kind of give you a brief overview of kind of the realm of possibilities that open up for victims that make it easier for courts to offer, to award custody, award child support, give protection orders, and remove from the discussion the arguments that will be made by a perpetrator that, well, Your Honor, you might think I'm an abuser, but she's a criminal because she's an immigrant, so I should get custody of the kids. And so what's important to understand is that when you file for VAWA or U visa relief, very shortly, like within weeks after you file for relief, the victims' cases are entered into a system that helps protect them from deportation. It's a special computerized system within DHS that essentially puts a red flag on those cases and says, do not initiate enforcement actions against these people. Two, that once people file for particularly VAWA self-petitioners, their children can begin to qualify for certain immigration benefits. Same thing for victims of cancellation of removal. VAWA self-petitioners get access to public benefits and some state benefits within 3 months of filing. Approved U visa victims, So again, you get certification early, you file your case. When your U visa case is approved, U visa victims become eligible for health care under the Affordable Care Act. And some states offer additional benefits. My most exciting, this is the first time I've been able to talk about this publicly, but the Department of Homeland Security, the VAWA unit, has very recently, over the last 3 or 4 months, significantly staffed up their unit. They added 152 new officers. They reduced the backlogs on VAWA and U visa cases by at least 74%, and they are running right now from filing to access to work authorization at about 6 or 7 months, so that there's beginning to be some predictability in this that again helps if you think about the timing of when you might be filing a custody case, for example. VAWA confidentiality protections, which keep the perpetrator from providing information to DHS that they can rely on against the victim, keeps the Department of Homeland Security from showing up at courthouses and trying to stop victims if that is happening in it. Let me ask you a question. Have any of you in the last 2 years, raise your hand, had the Department of Homeland Security show up at a courthouse and try to find one of your clients? 2, 3, good. The numbers are low. 4, okay. So there's a few of them still happening. That is, it's not supposed to be happening. There are policies against it. We have, if it happens, call us. We have, and there are materials and training materials and people at the Department of Homeland Security that we can call to make sure that does not happen. Judges will, as you talk to them about U visa certification, will also be interested in knowing that DHS isn't supposed to be showing up in their courtrooms. And then finally, that if you are, once you get your VAWA self-petition approved, if your perpetrator is a citizen, you can immediately apply for a lawful permanent residence. The waiting time for people, if your perpetrator is a lawful permanent resident, is about 5 months on VAWA self-petitions right now, and then it's 3 years after you receive your U visa application. So let me explain. So what's happened as well is that many U visa victims now, because they're going through visas so quickly, will receive what are called wait list approvals. And it means the case is essentially going to be approved, but there's no visa available this year. Those victims will get deferred action and work authorization, which means when they go to court for their custody case, they'll be able to work. They'll be able to make a decision about telling the courts that in fact they're not undocumented and not going to be removed from the United States, which should help strengthen their position in the family court case. So now what we're going to do is turn in a little bit more detail to the U visa certification process and judges. And so what happens is that the general requirements in applying for U visas are that you have to be a victim of a qualifying criminal activity. And what that basically means is it doesn't mean there has to be a conviction already. It means that they use criminal activity so that victims can come forward as soon as possible in the case, and that a finding of probable cause or a finding in a protection order or making a police report could help establish that victimization. Victims have had to be helpful in the detection, investigation, prosecution, conviction, or sentencing, and they have to possess information about the crime, and the crime must have occurred in the United States or violated U.S. law. In terms of certification, those are the only factors that a judge or a police officer or prosecutor will look at for certification purposes. In addition, when the victim files her immigration case, she will have to prove to DHS that she suffered substantial physical or mental abuse as a result of the victimization. And that's the main difference between the U visa certification requirements and the requirements for filing. And sometimes people get confused and they think they have to, that the certifier has to decide on substantial harm, and they do not. Okay, David, we're going to go to video 2. Am I doing this?
We're going to go to video 1, so it's the one that's clicked. Leslie, can you? Perfect, and go ahead. Once again, there'll be a little.
To know before they go into that room, what are they they trying to learn?
Okay, I'm going to pause this for a second. We got a number of people. If you are hearing this through your computer, you may want to mute your phone. Other people cannot hear it through their computer, so we're playing it on the phone.
What are they trying to offer the victims to get the best support and the best help for these people?
Well, we're not trying to reinvent the wheel. We interview people on a daily basis. What we need to know is that we're going to be face-to-face with a unique crime victim that's going to have some additional fears and barriers in place that are going to keep them from feeling comfortable sharing information with us. So I think it's, again, really important for us to recognize our role and get our role out there in the open early on in this process and this interaction with the victim, that we're not here to worry about your status. We're not here to check your papers. We're here because we're investigating a crime.
Yeah, I'm sure a lot of these people, too, are afraid they're just going to be sent back. You know, they're not going to be able to stay in this country. What kind of immigration relief may be available for somebody who's undocumented and they're a victim of crime?
The victim is identified as 3 basic forms of relief that they can request or file for in order to assist law enforcement in that investigation or prosecution that's taking place. One of them would be continued presence. Another is the T visa, and the other is the U visa.
Continued presence is the first form of immigration relief that's available to a victim of trafficking who's not otherwise admissible to the United States, someone who's here and is undocumented. And it's essentially just like it sounds. It allows a victim of trafficking to continue to remain present in the United States, provided that they're a victim and they are a potential witness in an investigation. It is designed to be a tool for law enforcement to keep someone who is a victim of trafficking, but also a potential witness in their case, around in the United States when they may not otherwise be able to stay here legally. In addition, once they have continued presence, you have not only that short-term form of immigration relief, but you have it connected to other services that serve to support and stabilize that victim.
You talk about continued presence, and you mentioned the T visa and the U visa. What's the T visa and the U visa? How are they different from the continued presence?
The T visa is a longer-term form of immigration relief that's initially good for up to 4 years. The criteria are that, like continued presence, a victim has to be a victim of trafficking. Victims also need to be cooperating with law enforcement requests for assistance in the investigation, and they also need to be physically present in the United States trafficking or due to the subsequent investigation into the trafficking activity.
U visa does include human trafficking as one of the qualifying crimes. However, the U visa also has many other qualifying crimes where someone could be a victim of those crimes and potentially be eligible for the U visa.
Okay, and is there a place you can find a list of the crimes that qualify for this?
There is. There's actually the DHS U visa resource guide, which the Department of Homeland Security put out, has the list of the crimes, and it also is a great resource for any law enforcement agency. We have frequently asked questions that are in there on the certification process, the list of crimes, what law enforcement agencies are doing when they sign the certification, what they're not doing, their rights, roles, responsibilities. All that's included in that law enforcement certification.
So why is it important for officers to have the knowledge of human trafficking and the immigration relief that's out there to help these cases? Why is that knowledge so critical?
It's so important for us because we're missing the boat across the country with this. We don't have this knowledge, and we're not identifying these underserved crime victims. We're not identifying these very dangerous perpetrators that are out there in our community. And we're about community safety. We're about victim safety, and we want to go home to our families at night. And so the realization comes in real fast when you start to see the perpetrators that are committing these kind of crimes, that these are dangerous offenders. And if you look at the law enforcement officers that are killed in the line of duty, murdered in the line of duty across this country every year, you can make a connection to a lot of the crimes that this kind of relief covers. So it's a big benefit to us to keep us safe out there on the street as well.
I think we also can't overstate how critical crime victims are to the outcome and success of our criminal investigations and subsequent prosecutions. Victims of trafficking and other types of violent crime have so many vulnerabilities, and one of the vulnerabilities we tend to overlook is this lack of legal immigration status. So if we can address, at least in the short term, the immigration status issues, we can get a little bit closer to a victim who feels safe and secure so that they can embark on that journey to becoming ultimately a witness in the investigation who can be credible and reliable and support the case.
And there's no better feeling when you start the process and identify one of these crime victims and identify and apprehend one of these perpetrators, and then you work together with your federal law enforcement counterparts, and in the end, sometimes you uncover other victims that weren't initially identified at that case, and you take, one or more of these violent criminals off the street as a team effort. That's what it's all about. It's all about the collaboration between state and local law enforcement officers and our federal law enforcement counterparts that are there to help us do our job.
So, to give you an idea of the types of crimes that are covered, it's a broad list of crimes that are covered. That was a clip from a training video developed by the Department of Homeland Security that NIWAP collaborated with them on. And it is also, and so the goal here is to cover a broad range of crimes, and this gives you an idea of what they look like. So we're seeing lots of questions about helpfulness, and so we're going to turn now very brief to talk a little bit about what helpfulness means, particularly in the context, and particularly spending some time in the context of how that happens, how it comes up in the context of a court certification. It's somebody who has been helpful, is being helpful, or is likely to be helpful in the future, and that they don't have to, they could have initially cooperated and then changed their mind. What we're finding from research, again, is that over time, significant numbers, over 70% of U-Visa victims, ultimately do provide some form of ongoing cooperation, but there is an exception should that their ability to cooperate be harmed, be affected by the perpetrator's threats or real physical harm to them. They can still get their U-Visa and get lawful permanent residency under the U-Visa if they can show they didn't unreasonably refuse to cooperate. David.
So great. Well, thank you, Leslie. So let's ask an next question of the audience, and if I can get this to go. Sometimes technology is being, I am unable to get my feedback. So let's go right, just true or false. If helpfulness can be satisfied when a survivor makes a police report and no criminal charges are pursued. Oh, I finally got the piece. And no criminal charges are pursued by law enforcement. So is that true or false? That helpfulness can be satisfied even when a survivor makes a police report and no criminal charges are pursued. And go ahead and write in the text chat. I see a lot of people are writing true. In fact, I'm not seeing any falses that have come up.
Oops, just a couple.
A few have come up, I guess. I think I'm getting, my computer is getting slow, so I'm a little bit behind. So Leslie, I'm seeing that on the whole, people see this as true.
That is in fact true. And that, again, the goal was to get people to come forward, and the way Chief Pete Heline testified before Congress on this, and I like the way he talked about it. He basically said every time a victim comes forward and talks about the abuse and gives information to law enforcement, that's not 10,000 visas, it's 10,000 tips and leads. It's 10,000 people that are potentially seeking court, going to court and talking about the abuse and getting protection orders. So it is incredibly helpful to the justice system and to the victims. David?
My computer has just closed on me, so we're gonna be posing a question to the audience. So Leslie, if you can just do the slide, but I'm not able to see the results at the exact minute. Chad, if you can.
David? Go to the next question because I don't have control either to go to the next slide.
No, I am. Chad, can you give the slide to Leslie? My computer just crashed on me.
Okay. Whoops, too fast. Okay.
Now I'm back.
You're back now? So I guess this comes back to...
Trues and mainly falses, and now what factors may be present in a state family or criminal case that would show helpfulness? What facts do you think would be present in a state, family, or criminal court case that would show helpfulness. So let's get a list of people from the audience on what do you think would be helpful.
So we've got testimony at trial, eyewitnesses, cooperation in the process. There might be evidence in a protection order, testimony that she filed a police report, she sought a protection order, she may tell the judge she called the police, she may testify that she met with the DA, exactly. She may actually show up for court dates. All of those are ways in which the court would hear or have evidence that she has been cooperating.
I think it's also important, Leslie, there was a question before about what about family court? There's a lot of judges who are sitting not in criminal calendars who are saying, well, this doesn't apply to me because I'm not detecting crimes, I'm not prosecuting crimes. I think it's really important to make sure that the advocates and everyone on our call understands that what we're talking about is helpfulness can be just the detection of criminal activity, that itself is sufficient. And I think sometimes my colleagues forget that. Just because we happen to be sitting in family court or in civil protection order court doesn't mean that we can't also detect crime based upon the testimony that's being presented to us.
Exactly. And David, can you advance 2 slides, please? Or
advance the slide, yes.
Okay, so, and then if you go to the next one, perfect. So maybe, Judge Gonzalez, you were talking about family court. Maybe you should go there first, and then we'll go back up to the criminal court if there's something from this. These are some of the examples of how it could be helpful in a family court case.
Yeah, and I think that this family court, civil court, is probably the biggest challenge because it's very hard for my colleagues who have exclusive calendars that are either family or civil court protection orders. When you present them with a request to certify something and they say, well, she's potentially a victim of a crime or providing helpfulness towards the detection of crime, they just really don't really feel like that's their purview. But it's really important to educate the judges that the issue here is not that someone's going to get arrested, that someone's going to get prosecuted, that someone's going to get sent to prison or jail based upon the words that are spoken in his courtroom, in his or her courtroom. It's really about an opportunity to give victims a voice and to allow them to be that lead that Pete was talking about, that open the lines of communication between victims and the judicial system, the law enforcement system. And sometimes the only time that a victim may necessarily be as open and frank about what's going on in her life is when she's sitting there in a protection order, quite possibly the first time with an interpreter who is able to make sure that she is able to finally fully participate and have access to justice. So whether it's a protection order or whether it's because her child was removed from on a child in need of protection or services child welfare case, any of those situations in which the judge sitting in the court says, whoa, there's something going on here that I need to investigate further, that's enough for a judge to start thinking that perhaps there is some helpfulness there, that there is detection assistance that can be made for the detection of a crime.
Judge Gonzalez, this is Leslie. We had an interesting question from one of the attendees that I think would be interesting to hear your response to, is that when you do, let's say, an ex parte order, a temporary protection order, and a protection order cases, would a judge be detecting in that context too, or how similar is that potentially to probable cause in the criminal case, and what's your view on that?
Well, I think it's very akin to probable cause because, if you're given that information and the request is made, the judge can always ask for more information if they want more evidence to get to the level of probable cause. But I think that's a very appropriate time to approach the court.
Okay. David, can I have the control? There we go. Okay. So, Judge Gonzalez, could you talk a little bit about where I know because you've sat in both criminal and family courts.
Right.
Criminal court case, if you were in a criminal court, when might be the possibilities or the appropriateness of approaching a judge for certification?
Well, criminal court is probably a lot easier because my colleagues are a lot more comfortable in this arena. But any time where the court is making any kind of a finding of probable cause, either to issue a bond, to not give bond, to grant a criminal protection order at the request of the state, almost any of those opportunities can be presented to the judge and say, hey, can you sign this certification based upon the hearing that we just had? Or judge, this victim wants to come forth, but they can't, or they need some assistance to be able to talk to law enforcement. Can you take a look at what her statements have been to the prosecution? She did give a statement to the grand jury. Can you take a look at this? You know, all of those opportunities are available. But again, someone's got to come forward and ask the judge. And you can't be afraid to educate the judge that this is an option that he has, because judges are very busy. Their calendars are full. And if you present them something that they're not familiar with, they're probably going to say no, unless you give them a reason to say yes. And part of that is educating the judiciary as well. And I would love to say that we have judicial education that really concentrates on the subject, but the fact of the matter is that many of my colleagues, especially in Middle America where I sit, may not have one of these requests, maybe one or two in their lifetime. So you can't expect them to have this information and know it. So I would encourage everyone to take a look at the judge's toolkit. And I mean, if you're an advocate and you've got a situation with the judge, be ready to give the judge a heads up about that before you make your request.
And I'm going to ask you another question, Judge Gonzalez, that came up around, so when you're in these earlier stages, let's say of a criminal court case, when the judge is making a probable cause determination or they're thinking about certification, are they relying on the criminal court record, like kind of what's been filed at that point to make certification, and how does that seem appropriate to you?
Well, I think a judge can use anything that is available. If there is testimony that has previously been accepted by a court, I think they can use that. If it's testimony, because in many jurisdictions, it's a court commissioner that hears one hearing or some other judicial officer that hears the initial hearing, and then the second officer that steps forward. So if you can't get to the initial officer, I think that certainly I could use the court record.
And let me just ask you, going back to the family court questions again, and I think we're getting a little ahead of ourselves, but I think this is a good time to discuss it, if you're in a family court proceeding, you do your temporary order, you said you could certify at that point. When you're the judge hearing, let's say, a custody trial or a contested protection order case, at what point do you think would you think it would be best for the advocate or the lawyer working with the victim to approach the judge for certification? Well,
and here's the rub. The certification that is supposed to be to encourage the helpfulness, right? And so at some point, the advocate or the attorney representing the party is going to come to a point where they're going to say, I know there's something going on, but I can't get my client to talk, and I'm going to have to figure this out. So it may be long before any of that testimony comes into court that the lawyer or the advocate may approach the judge and say, Judge, I have this client, and clearly it has to be done with both sides knowing. I have this client, and I think there's an issue here, but we're having a difficult time getting to the truth. So that it doesn't have to wait till the end, because if you wait till the end, the opportunity to get the information, the facts the judge needs to make the decisions, it's too late. It doesn't help you if you find out about a situation after the judge has rendered a decision in the case. So trying to figure out when is the appropriate time. I know that, David, can I have the slide? Thank you. And then I know that in law enforcement, there's a lot of different times of points in which they can have helpfulness too, and there's a lot of times that helpfulness can be met, and there's lots of materials on this. There may be questions that judges ask
about, if the perpetrator's dead or if the victim's dead or if there's, the prosecution is going forward or not. There's lots of really good information about that. But what I want to get to is some of these issues is that sometimes I think, I agree, Judge Gonzalez, it makes a lot of sense to try to come earlier. The other thing that courts may see is that advocates or lawyers are coming after the judge's ruled, right, in a protection order case or a custody case where they've already made a finding. What are your recommendations if, the case comes to, let's say, the immigration lawyer after there's been a protection order about going back to the protection order judge and getting certification? How common do you think that might be or should be?
Well, I think courts should be open to accept those requests for certification at either point. But it's going to be, I would have to say that it'll be a little harder if you come after the fact, because the judge is going to probably a little bit more suspect of what the motivation is. So in that case, I think it really behooves the advocates to educate not only the judiciary but the immigrant community about the availability of these options, because it's really important to try and not reinvent the wheel later, especially if there was recantations for all sorts of reasons at the time of the original protection order.
Some of what we're seeing nationally through technical assistance and with judges that we're working with as well is that some judges will issue the protection order and then immediately sign the certification. So in the protection order context. So they've made a ruling, and then based on their ruling will issue the protection order and sign the certification and then attach a copy of the protection order to the certification, which is certainly a perfectly appropriate way to do it.
In fact, I think that's probably best practice, because you're already there. You're already in court. You've already made the findings. It's very appropriate to do it there, rather than making the litigant come back to court a second time or a third time to get that certification. And
so in a family court context, that could come up. Would that, I'm sorry, I'm having trouble. Okay. So in a family court case, then, that could come up in a custody, protection order, custody, divorce. Like, you could have rulings in any of these kinds of cases, and that essentially right after the ruling, if not before, could be an appropriate time to seek certification. Correct. I think that is very valid. In fact, to me, that would be the time that it would be freshest in the judge's mind. And again, what benefits the courts is the options that we have then available to us if the individual has status. And those options open up the choices that the judge has and the decisions and the orders he makes later. So the earlier we can deal with this issue of certification, the better, in my opinion. So let me ask you a question. In terms of, let's say it's not a certification case, it's a case that's a VAWA self-petition, and so that you don't have to have certification. What would be your view if you had two cases before you, and in one case the self-petition got filed and she was in, it was 3 months down the road and she had some access to benefits, versus somebody who went to court and then later filed for immigration relief? How would that differ in terms of what your options as a judge would be? Well, if she has status, then of course we have there's a support options. There may be in some states, unless you have status, you don't get any benefits such as public housing assistance or medical insurance and even a driver's license. So some of those things, the day-to-day operation of a person's life, sometimes impact what you do in a divorce or a custody case. So clearly, if you have those options available for you, that would make, in my opinion, the coming to a justful decision that much easier. So that it may be best practices, or I would think it would be the best practices based on what you're saying, that if people are screening early for immigration options, if they find out that somebody's eligible for a VAWA self-petition, they should go forward and try to do that. If they can, get the case started before they're before a contested case in a custody case or protection order or divorce case. If in fact it's a U visa, then you're going to want to try to do it as soon as you can when you're before a judge if you can't get another way of certifying, or at the latest once the judge has ruled that the violence has occurred.
Exactly, exactly.
Can we just, there's a question just to clarify, I think that you're getting to this, about family law judges certifying when there's no criminal justice involvement at all. There's just a protection order or a custody proceeding. Would they still be able to do that? That was a question that's been posed a few times in the chat.
Yeah, and Leslie, I think I tried to allude to that earlier. I saw that question before, and again, the issue is not whether somebody is arrested, whether somebody is prosecuted, whether there's an actual person that goes to prison. The issue in those kind of cases for me is detection of criminal activity. And a judge can detect criminal activity, can assist, can see that someone can be helpful towards the detection of criminal activity no matter what kind of case comes before the court.
And so that a family court judge could do that, just getting clarity, a family court judge could do that even if they're not in a criminal case.
Absolutely. This is Leslie. And what I will say is and this is a good time to announce, about a week and a half ago under our State Justice Institute grant, we did a broadcast webcast for judges on issues that arise in family court. And Scott Whalen from the Department of Homeland Security was there, and Judge Livingston from Texas was there. We discussed this issue, and in fact, DHS is approving is getting U visa certs from protection order judges.
And just to clarify does that mean that the victim has to go forward and report to law enforcement or not?
No.
Right. So they do not need to report to law enforcement with the certification process. Just to clarify that, because I'm seeing that question coming up in the text chat.
Leslie, correct me if I'm wrong, but my understanding is that the issue is, can this person show that this will be helpful at any point? It may be when they are comfortable stepping forward to law enforcement. They are not forced to go to law enforcement.
Right. That's right. They have to show ongoing helpfulness. So what might actually happen is if you see it, say the protection order court is the court of first entry. Once that victim gets a positive ruling in a protection order court and gets a certification, what we're seeing again in national data is that ongoing reporting, both from U visa victims and VAWA self-petitioners, continues and goes up nationally when victims have already started to get relief. Now, in order to get lawful permanent residency under the U visa, let's say she got a certification in her protection order court, never went to law enforcement and reported it, to get lawful permanent residency, she's going to have to show that she was willing to be ongoing and cooperative, or show that her refusal was not unreasonable given the threats from the perpetrator, etc. So the case ultimately might be a little harder, but it's not impossible. And actually what we're seeing is that early certification in whatever context, over time the victims gain strength and the courage and the trust of the system and do end up cooperating. So I would say that it is not required. Best practice might be to get the protection order, and then you can make police reports that are not filed at the moment of the scene of the crime. You might, as a good advocate or lawyer, do that as well. But yes, there are a range of ways these can go forward, and that's what Congress intended. They intended to open up the justice system. One of the other things we're seeing in our most recent survey on work authorization that we're going to be publishing next week is that use of the civil justice system goes up exponentially as victims begin to get approval of their VAWA and U visa cases, which is, I guess, feeds back into what Judge Gonzalez was saying.
I do want to note, Leslie and Judge Gonzalez, that we only have 10 minutes left, and we still have a few things that we want to cover. This is a great discussion, and there's a lot of great questions, but I do want to make sure that we get to some of this material.
Okay, so I think at that point, I wanted to skip if you don't mind, Judge Gonzalez, I want to turn to just very briefly what the certification form looks like and how it would be filled out by a judge, and then try to reserve a few minutes for questions. Because I do feel like we're covering all the material that we intended to cover, so that's really good. When a judge fills out a certification form, the main thing that you want to look at on the first page is to make sure that in this bottom part 3 that they're checking off any crimes that they've detected. So that might be domestic violence, it might be kidnapping, it might be sexual assault. If in fact what they detected was stalking or forced labor, there's a new fraud and foreign labor contracting, okay. Which are the 2 new VAWA 2013 crimes. You're going to need to check the other box and write in stalking or fraud and labor foreign contracting. What you'll see here is, as opposed to what a police officer would do in box 5, they're going to say, I have probable cause to believe that husband strangled me, Miss Zorloff, or my mother as the case may be, during a domestic dispute, and that my movements were tracked. So you state some facts, some description about the helpfulness that there were, the protection order judge saw some photographs that the law enforcement took. And then the most important is this last page, which I'm going to turn over to Judge Gonzalez to explain to how judges need to fill it out.
Well, and I think that this is where the biggest challenge comes for advocates and for attorneys, because if you're going to do this with judges, you need to sort of give them the language that you think will work. And in the next slide, we're going to give you some of the languages that we're talking about. But there has to be a finding based upon facts that there is helpfulness. And the example that you have here, again, has facts. It can't just be the opinion of the judge. It has to be something based upon facts. So based upon my having probable cause, I certify blah, 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 that she suffered this injury, or that she is a victim of stalking, and specifically you set forth some facts. Because I think if the certification is not supported by, if the helpfulness section is not supported by facts, it will be deficient.
Correct. And then the other thing that's really important is, do you see how this sample form crosses out some language and then puts something else? Judges do this all the time on court forms, right, Judge Gonzalez?
Yep. If we don't like it, we cross it out.
And that's the only way a judge can complete the certification form, because these forms were not designed for judges, even though the statute authorizes judges to sign them. And that DHS is in fact accepting forms amended this way by judges. So if we go to the next slide, you'll see the various different ways. And Judge Gonzalez, maybe you want to summarize this a bit.
Yeah, so basically, again, if I'm an advocate or an attorney, I'm ready to assist the judge in making those modifications. And because it is, they can go ahead and modify the form, and the language can be either for a probable cause, civil protection orders, custody case, child welfare case, whatever. But don't be shy about telling a judge how to change that form.
And so the next thing I think I'm going to skip this video because we're running out of time, but what I want to tell you is what it says, and you can go and look at these law enforcement videos. Because another thing judges might want to know is, well, if I sign the form, am I giving somebody immigration status? And what this video, DHS says in this video is no. We decide immigration status. All you're doing is saying they've been helpful and you believe they've been a victim of criminal activity. After that, it's up to DHS to award the relief. I just wanted to show you, we have a brand new Judges Certification Toolkit. The version that's up on the web at this point has been approved by the State Justice Institute. It includes kind of decision trees about how you would go to the court, some sample motions, and ways to think about approaching the judges, and Q's and A's that you can use to answer questions from judges that you may be working with. I'm going to skip. I already talked to just have a few minutes. We have 5 minutes left for questions. One that I'd like to answer first is somebody asked whether or not if you request certification from a judge, is it confidential. This is a big difference between law enforcement certification from other sources. When you file a U visa or a VAWA case, that case is confidential. If you're requesting certification before a judge and you're in a case where there's both parties, the parties, I believe, would have to be aware of the certification. Judge Gonzalez, do you have what's your view on that one?
That's correct. No, with due process, you'd have to give them notice.
That's a big difference between that might be a drawback in some cases or a safety concern, but if you're in a jurisdiction where that's the only place you can get certification, what's important to know is, yes, he may know you're getting the certification from the judge, and the perpetrator may try to then provide information to DHS, but VAWA confidentiality precludes DHS from relying on that information. David, I'm turning it over to you for questions.
Okay, and we're getting lots of questions. I do see a lot of people on the website for the materials, including slides from today, due to high demand, has been down. So I do recommend just checking a little bit later. You will be able to get copies of the slides. We will also be having a recording of this web conference. There's a lot of questions, Leslie, that we haven't had a chance to get to, but so how will you be answering some of these questions? Because I think if people will, because I know you're going to get to each of these.
So the way we're going to be doing it in our new OVW grant, we're going to have a newsletter that we're going to be coming out with every couple of months, I believe. And so we're going to take many of the unanswered questions from these and other webinars and group them by topic and provide answers in like a Q&A format or a newsletter type format. One of the questions I did get is that I think it's important to understand, if you're working on providing certifications or seeking certification from a court, from a police officer, from Child Protective Services, etc., it is very important to your relationship with that certifier to understand how they best want to receive the information. So if I were approaching a judge for the first time and they're new to the certification, I might give them a draft form filled out based on the facts, as people do in findings of court orders all the time, but I would also give them a blank. And then, if I knew them, I would want to know: do they prefer to fill it out themselves, or do they prefer me to help prepare it? Because you don't want to give the judge the impression that you're trying to kind of control what they write. And so I think it's important to know how your certifier. Any suggestions, Judge Gonzalez, from your perspective on how to approach the form question?
Well, I think it really is about your particular judiciary and your particular judge. And it also is about sort of making sure that your judiciary in whatever jurisdiction you're in is familiar with the toolkit and is ready for it. Because it's really difficult to approach a judge and give him that kind of education on the fly. If you have done the work in advance, I would suggest you do both, a filled out form and a blank form. But it really is a touchy subject, especially when you start talking about issues of due process with the other side and protection orders and ex parte communication with courts. You may find some roadblocks there that you can alleviate if you've given the judge just general information before you come in with a specific case.
And I think the last point, there's another question that feeds, I think, very nicely into that, is because U visa certification and U visas have no time limit after the crime on which you have to file for a U visa. Courts, you may be in a position of approaching a court on a case, particularly in a criminal case, let's say, where they ruled 10 years ago. A judge can certify, but again, you're going to, in our toolkit and in the DHS manual that you saw Scott refer to in the video, there's good responses to that. So you want to brief the judge so that you're trying to anticipate a question, particularly if you're coming back with a case that was a bit older, because certifications are clearly available at that time. But whether it's a judge or a law enforcement official, they're going to want some explanation.
So unfortunately, I have to say we have come to the end of our time. And I want to really thank, there is information about getting further I think we were both, we were moving too quickly, both of us at the same time, Leslie. So there is technical assistance that you can available. There is the PowerPoint. As I said, the website's down now. We will be getting an email in about a half hour with information with this link also. You also can contact NIWAP directly. There's both the phone number and a email address that is available. So I want to encourage you to be able to do that. And I guess I was here, and for technical assistance for courts, there is also a wide variety of resources that are available. So courts can also be getting the technical, for advocates, for attorneys, and for courts, we do have the technical assistance available. So thank you so much. Leslie and Judge Gonzalez, any last words before we go?
My last word is that through our State Justice Institute, we're able to provide direct technical assistance to judges and court staff. So please do call us, and we can provide that information. That's in addition to the technical assistance we provide to advocates, attorneys, police, prosecutors, and others through our OVW grant-funded work.
And those of you who have issues with my family court colleagues who are hesitant, just be patient and educate, educate, educate. They will come around.
Okay, and I think educate, 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 build relationships, build relationships, build relationships. So thank you all for joining us for today's NIWAP web conference on new visas. We appreciate having you. We encourage you to join us. Next month we'll be having our next the 7th of this web conference series, and you'll be getting information very shortly about that web conference. Thank you for joining us. And we will, and you will get the web and evaluation email request in about a half hour. Thank you much.
Thank you. And the next web conference is on trauma-informed work with immigrant survivors. Registrations are accepted now. If you register today, you will get a link saying your registration didn't go through, but it actually did. We're working on that problem.